Good afternoon, Steve Smith here at SCORE, Fairfield County. Welcome to today's webinar, Keeping Lawsuits at Bay. Our speaker today is Cliff Ennico, and I'll give you a more formal introduction of Cliff in just a minute, but I am obligated to give you just a little bit of information about SCORE. Many of you, as I can see from the names that have joined us, are familiar with this information, so I'll go over it relatively quickly, but SCORE Fairfield County is a part of the National SCORE organization, of which there are about 320 offices throughout the United States. SCORE Fairfield County is in Norwalk. We have about 100 volunteers here, 2/3 of which are retired and 1/3 of which are still working. We deliver primarily 3 services to small businesses throughout Fairfield County. One is our counseling service, which is generally done in our offices on East Avenue in Norwalk. It's on a one-on-one basis, and you can schedule counseling sessions at scorefairfieldcounty.org. I'm going to mention that website probably 10 more times, so don't panic if you didn't get it that time. The other thing we do is webinars, and you're on one, and workshops. The workshops are held primarily at libraries throughout Fairfield County. The webinars are actually done, of course, like we're doing it right now. Again, you can get the full schedule of workshops and webinars for the next month, or actually more than a month when it comes to webinars, at, again, scorefairfieldcounty.org. We have experts on everything from individual topics like technology and not getting sued, which is what we're going to talk about today, to more general business topics like how do you start a business, how do you get your business more profitable, how do you grow your business, those kind of very important ideas. Okay, so as we get ready to go forward here, I'll just mention that our next webinar is January 24th, and at that time, Budley Freund will present basic technology trends. For those of you who have been with us on the webinars in the past, you'll think, well, yeah, we've heard Budley do that. No, you actually haven't. Because of the speed with which a lot of this technology is moving and sources and information relevant to it, we're going to be running these technology webinars on a quarterly basis to make sure we keep you all up to date on what's going on. So this will be the latest and the greatest. And you'll be getting email reminders about that from scorefairfieldcounty.org. Now, today's event, we're going to end this sharply at 1 o'clock. The slides will be available at scorefairfieldcounty.org within 5 days. So make sure you go there to refresh your views if you need to. We're going to set aside about 10 minutes at the end for Q&A. Register your cues in the chat room down in the lower left-hand column of your screen. And about 10 minutes of 1, we'll take those. I'll be picking the ones I like the best, frankly. And so we do need your questions. Also, this is new because I can tell some of you have been in these webinars before. At the conclusion of this webinar, you're going to be receiving an email asking you to evaluate the quality of the webinar. So when you see that, it's not spam. Please do it. It helps us keep ourselves on the straight and narrow. Also, if you haven't already, you'll be receiving from Fairfield County a questionnaire either tonight or tomorrow asking you for input on the content of our 2017 workshops and webinars. Obviously, that's really important to us because that becomes the basis of our education program. So watch for that as well. Now, on to our speaker. Cliff Ennico's been on the webinar program with us before. He also speaks at our workshops, live face-to-face workshops regularly. He's an attorney, author, columnist, speaker, television personality, astronaut, not astronaut, but humorist, as you'll see during his presentation. He's one of North America's foremost small business experts, helped more than 15,000 small businesses get off the ground and flourish over the last 32 years. He actually had a stint on Wall Street as a lawyer and business development consultant, but we're not going to hold that against him. He's the author of at least 10 books, and two of my favorites are the Crowdfunding Handbook, for which he's actually done a webinar for us, and you can go into the webinar archive and look at it anytime you want to at scorefairfieldcounty.org. And then 27 new ways to create and build a breakaway business. That's really cool. And of course, we need to talk about doing that as a standalone webinar, I think. So he speaks nationwide to corporations and business groups. He's all yours for the next 45 minutes. I'm going to turn it over to Cliff right now. Cliff, go ahead.
Hey, listen, thank you very much, Steve. Much appreciated. Well, first of all, thanks to all of you. I'm always flattered that people are actually willing to take time out of their busy day to listen to a lawyer yammer on for 45 minutes about a topic that, let's face it, is not going to put a nickel more into anybody's pocket. The marketing programs always get big audiences. People always want to know how to sell more, how to attract new customers. This is not going to help you with any of that. This is defensive stuff that we're talking about today. How to protect yourself, how to protect your business, which is important too. As I always tell people, and SCORE's been saying this for as long as I've been working with them, which is a very, very long time, it isn't how much you make, it's how much they let you keep. So that's the way to look at this. Moving quickly through some stuff here. If you don't believe I'm a lawyer now, this proves it. We always tell you what we're not going to do before we tell you what we're going to do. Obviously, I am not an employee of SCORE. I'm a very dear friend of SCORE. I've been doing programs now for 35 years, but I am not acting in any official capacity. So, if you listen to something I say and you think it's a good idea and you do it and you get sued left and right and you end up filing bankruptcy and living in a diaper box under the Brooklyn Bridge, you can't really sue anybody. So there. Second one's a little bit more important, legal and tax. Whenever we talk about anything involving legal and tax stuff, you got to remember we're just giving out information here. We're not giving out one-on-one advice. I'd have to know you and your situation a lot better before I could give you, advice in any professional capacity. So, while we will be talking about some legal and tax stuff, you really should be getting that advice from an attorney or accountant, tax advisor, financial advisor, someone who's admitted to practice and who can work locally with you. Now, this last disclaimer probably disqualifies me from doing this program completely, but I put it in anyway. I'm a little bit of a fraud today. Normally I'm not, but I'm a little bit of a fraud today. While I do work very hard to keep my clients out of court, I am not a litigator. I do not myself fight courtroom battles. I'm proud to say that I have only seen the inside of a courtroom on 2 occasions in my 36-year career. Once when I was sworn into the New York bar, and the second when I was sworn into the Connecticut bar. And I want to keep it that way. So seriously, if anybody ever tries to sue you, do not call me. Please find somebody who actually knows what the courthouse is. And we'll talk about that in a couple of minutes, what kind of an attorney you need if that should ever happen. Okay, first of all, some good news here. People tend to obsess and get paranoid about being sued when they have a business of their own. But here's some good news. Anywhere in the country that I know, and this is not just Connecticut, but anywhere in the country, it costs anywhere between $10,000 and $20,000 to sue anyone for anything, except maybe small claims court. We'll talk about small claims court in a little bit. That's a big thing here. It means people are not going to sue you just because they don't like you. To spend that kind of money, they really, really got to be ticked off in a very serious way. You're not likely to get sued unless the amount is $25,000 or more. At that point, it does become economically viable. People will spend $10,000 to to pursue a $50,000 claim. They will not spend it to pursue a $5,000 claim. You injured a member of someone's family, especially their kid. Those of you who have daycare businesses or private schools or things where you're what we call in loco parentis, you're standing in the place of a parent. Something bad happens to someone's kid, they will sue you. Okay, you're counting on insurance for that. Or last but not least, the aggrieved party is extremely rich, has nothing better to do with their time, and really, really, really hates you. There are people out there who like to bring lawsuits for sport, believe it or not. They are independently wealthy, they got tons of money, they got nothing better to do, and they like to do this. It gives them, they get their jollies out of it. We'll tell you a little bit how to spot these people. One of your goals in life should be to try to keep these people out of your life as much as possible. But now the bad news. Even one lawsuit can potentially cripple or kill your small business, even if you win. And that's the big thing. Even if you go to court and you ultimately you get a judgment in your favor, you lose. Everybody loses when somebody goes to court. Whenever one of my clients gets sued, an angel dies. That's how I look at the world. It's going to be a tough thing. Our legal system is a little bit like the old roach motels. Those of you who remember the old ads for this roach thing, this roach trap that used to be sold back in the 60s and 70s. Roaches get in, but they never get out again. That was the ad. Our legal system is very much like that. It's easy to get into it, hard to get out of it once you're in. The cost of defending a lawsuit is every bit as great as the cost of bringing one. Your time that it will take will eat you alive. Meetings with lawyers, depositions, over and over again, back and forth, back and forth. Court dates, where you get there, you wait 2 hours, and they postpone you until the next month. It's just going to eat your life alive. If you have liability insurance, and you absolutely have to have it, settlement may increase your premium or render your business uninsurable. The premiums may become so high that you can't afford them. Last but not least, lawsuits and especially successful judgments against you have a nasty, nasty habit of appearing prominently in online search results. A client of mine, a guy I worked with for years, was sued. It wasn't even a business lawsuit. It was a domestic lawsuit 30 years ago. And if you search for this guy online, one of the very first things that pops up on your search engine query is this lawsuit, this judgment that was rendered against him 30 years ago. It's a social media nightmare if you ever have a successful judgment against you. One of your goals in business should be to avoid lawsuits at all costs. And it even gets worse. You know, some of you are listening to this program because you're hoping I'll give you this great secret about how not to get sued. Well, let me tell you something. There is no secret here. There is no ironclad, foolproof way to keep from being sued. There is no magic bullet. You know, if somebody really hates you enough and they've got billions of dollars and lots of time to spend making your life miserable, they will do it. That's the bad news. The best you can hope for, though, and this is not nothing, the best you can hope for is to make yourself a very unattractive target for lawsuits, so that when most people look at you, they'll talk to their attorney, and their attorney will say, you know what, yeah, you can sue this guy, but there's nothing to go after here. You don't really have a strong case, and even if you do get a judgment, there's nothing there. You're just throwing good money after bad. Write it off on your taxes and move on with your life. That's the conversation you want the nasty people to have with their attorneys. And my goal in this program is going to be to try to get you there. Okay, so enough about preliminaries. Let's talk about the meat here. There are 5 strategies that you can use. There's maybe more, but these are the 5 basic strategies. If you are following these 5 basic strategies, you are doing as much as any human being can on planet Earth to keep lawsuits at bay. Let's run them down real quickly, and then we'll spend some time talking about each one. Number 1, form a Corporation LLC or other legal entity and use it. That is very important, that qualifier. Number 2, take out as much liability insurance as you can afford. Number 3, put disclaimers in all of your contracts, invoices, purchase order forms, anything that you do with your customers, your vendors, suppliers. Get this disclaimer language in there. Number 4, consider transferring your assets into someone else's name. This is not for everyone. A lot of people like to put their house title into their spouse's name when they start a business. We'll talk a little bit about when that's effective, when it isn't. And then last thing, the most important way to keep from being sued, which I'm not going to tell you right now. I'm going to tell you that later on because it's too much fun. Okay, so I got to keep you guys around for at least another 5 slides, and that's how I do it. Okay, let's talk about number 1, forming a corporation LLC. A lot of people think that if they form a corporation or LLC, they've done everything they possibly can to keep from being sued. That's not true. A corporation or an LLC, while it's a very important thing to have, it's not a suit of armor. It's not something that will automatically prevent lawsuits from happening. What you are doing here, when you form a corporation or a business asset, you are putting up a wall between your business assets, the stuff that you use in your business life, and your personal assets, your house, your car, your stamp collection, whatever hobbies you have. The stuff that you don't use in your business is in a different place. When you form a corporation or LLC, you are taking your personal assets out of the equation. You are telling the world, when they see the Inc. or the LLC, what they know or they should know is that you're only liable for whatever you have invested in this business. Nothing else. They can't get your house. They can't get your car. They can't go after your kid's college tuition fund. All they can go after is the basket of whatever is in your business. But that's not nothing. The corollary to that is, even if you form a corporation or LLC, your business assets are still open to attack. If someone sues you and your business has substantial assets, let's say you're a contractor, you own cars, you have a fleet of trucks, you have all this, they can get to that stuff. Your house they can't get to, but they can get to all your business assets. That's the big thing that people don't realize. That's the limitation of corporations and LLCs. Okay, we'll talk more about insurance later on, which is, of course, how you protect your business assets. But the most important thing about corporations and LLCs is you must do all your business through the corporation or LLC. These things require a little bit of discipline. The corporation LLC name must appear on all your business cards, stationery, website. If you ever meet me at a networking group session and I ask for your business card, I guarantee 9 times out of 10 I will not be happy with it, because your corporation or LLC name is not there. You're Susie so-and-so, you're doing business as Susie's Fantasies. You have a corporation, you have an LLC, but I don't know anything about it. So if you do something and I get mad and I want to sue you, it's Susie who's going to get sued, not her corporation or LLC. You have to sign everything as the representative of the corporation or LLC. When you sign business checks, just write the word president after your name. Let them know you're not signing as Cliff Ennico. You're signing as the president of XYZ Corporation, who happens to be Cliff Ennico, but he's not Cliff Ennico, the personal guy, who's so much fun to be with. Last but not least, make sure you have a separate checking account for the corporation or LLC. All checks go through that account. You never allow people to write checks to you personally when you have a corporation or LLC, as painful as it is. And I sometimes have to return checks to people saying you didn't make it out right, and that's painful, believe me. When you have bills to pay and someone writes you a big, fat, juicy check with your name on it, it's very hard to say, look, take another week, but write it out the right way, please. But you got to do that. This is the discipline of having a corporation. If you don't do this, and I see people doing it all the time, you continue doing business in your personal name, a plaintiff, somebody bringing a lawsuit against you, can pierce the corporate or LLC veil and get to your personal assets. That's the legal term, where the court actually disregards your corporation or LLC and allows somebody to go after all your personal assets. It's one of the worst things that can happen to you. And by the way, a little piece of liberal arts stuff. If you ever want to win a trivia contest, where does the term pierce the corporate veil, pierce the LLC veil come from? It actually comes from Shakespeare. It comes from Hamlet. If you remember in Act 3, Hamlet kills Polonius, who was hiding behind a curtain, and he stabs him through the curtain and stuff and kills him. That's what the phrase pierce the corporate veil comes from. Shakespeare is responsible for a lot of things we do here in the law. Okay. Second strategy, get insurance. I just told you that even with a corporation or LLC, all of your business assets are subject to attack. So you got to get insurance on those things. And it's a good thing to do, because most plaintiffs' lawyers, I do know I'm not myself a litigating attorney, but I do work with a lot of attorneys, both plaintiffs and defendants' attorneys. And I will tell you something, most plaintiffs' attorneys would rather go after an insurance policy than someone's house. Trying to put a lien on somebody's house and doing a contract is a pain in the butt. It's much better to have a fat, juicy insurance policy where their lawyer talks to the insurance lawyer and then they work everything out. They'd much rather have that to go after. So for that reason alone, you probably want to have some insurance because it deflects, again, attention away from your personal assets. There are two types of liability insurance, depending on the part of the country you live in. The first type is called commercial general umbrella liability. This is slip and fall coverage. If you own a store, a deli, antique store, someone comes in and they slip on a wet floor and they break their butt, this is the insurance that protects you in those sorts of situations. Whenever you are in a business where other people are working on your premises, you absolutely have to have this coverage. What if you work out of your home? A lot of people ask that question. Well, there's two ways you can deal with this. Number one, which is my method, I never see clients in the home ever. I always meet them off campus on their premises and stuff, because that way it's their insurance, not mine, that I have to worry about. But also, too, if you must see clients in your home, let's say you're a dentist, for example, and people are coming into your house. In most communities, they have exceptions from zoning laws where dentists can work out of their homes. You have to carry this coverage. What you can do on your homeowner's policy is you can get what they call a home office rider, which will cover any business assets that are located within your home. You can get a separate policy of liability insurance, but usually getting the home office rider to your existing homeowner's policy is a much cheaper and cost-effective solution. The other type of insurance you want to get is errors and omissions insurance. For a lawyer or other professional, we would call this malpractice coverage. This is insurance against your screw-ups. You make a mistake, you're an IT consultant, you do a computer project for some big company, you cause a virus to get onto their system, and their whole data going back to the year one is wiped out. Believe me, you will be sued for that. Errors and omissions is the coverage. What we call E&O is the coverage that will protect you against those kinds of situations. Whenever you're getting insurance, always get at least what we call 1 and 2. $1 million per incident, $2 million overall. Depending on the type of business you have, you may need more. Just yesterday, I dealt with a client that was opening up a daycare center, and I suggested that she get 3 and 3. $3 million insurance per incident, $3 million overall. Why so much? Because she is taking care of other people's kids, and whenever something bad happens to someone's kid, they sue. I can't repeat that often enough. It's a guarantee. Okay, let's talk now about legal disclaimers. Okay, those of you who are familiar with contracts, these are those clauses that appear usually in all capital letters with language you don't understand. They talk about consequential damages and incidental damages and stuff, but they are very important. It is true, sometimes the courts will disregard these. They're not foolproof, but it's much better to have them in your contracts than not. And the simple reason here is, let's say that you do get sued and the judge likes you. The judge thinks you're right and should win. By putting these disclaimers in your contract, you are making the judge's life very easy. And if there's one thing judges like, I can tell you about this, they want their life to be as easy as possible. They want easy decisions. That's what they want. They don't want to have to think. They don't want to have to stretch the law. They don't want to have to make the law, because that's how they get overruled by higher courts and look bad. That impacts their career in a very big way. They want the cases coming before them to be as easy as possible. By putting disclaimers in your contract, you have made their lives very easy. And you've also, if they don't like you, you've made it harder for them, because now they have to work around your disclaimer language to try to rule for the other guy. And they're not going to like that. They don't like to work. There are two types of disclaimer. Warranty disclaimers. These are disclaimers that basically say, look, I'm going to do a good job for you, but I'm not perfect. Things may happen. I do a lot of work, many of you know, with eBay sellers, people who sell on eBay, and a lot of them do this. They put in their listings, look, I don't know nothing about this stuff. I found it in the back of a closet. I have no idea if it's a genuine Beanie Baby or not. I'll answer any questions you have, but, buyer beware. I just don't know what this thing is. That is a perfectly valid legal, it's not very good grammar, but it's a very effective legal disclaimer. It works. You're saying, look, I'm not an expert. I'm not an antique dealer. I have no idea if this is a genuine Roman coin or not. I have no idea. Okay. The one that's more important, though, and especially those of you who do services like me, this language is actually in all of my retainer letters. when I take on clients for the first time. I will perform services in a professional manner. I warrant the quality of my work, but I cannot guarantee that you will achieve a particular outcome. There are a lot of people who hire me to form a company, and they say, now, if I do everything you tell me to do, I won't get sued, right? Yeah, and seriously, and you should laugh at that, because I can't guarantee that. That's up to you and how you conduct your business. All I can do is make sure the corporation, I'll make sure the LLC is formed correctly. If there's an issue, if I see a problem, I'll let you know about it. But I can't guarantee you're going to have a perfect life, people. No lawyer can guarantee that. No professional can. So you got to do that. Otherwise, you have to manage people's expectations with these things. The other kind of disclaimer isn't really a disclaimer. It's a limitation of liability. I am not liable for consequential, incidental, punitive, or other speculative damages. That clause should appear in every one of your contracts, your invoices, your order forms, any document that you have with your customers, your vendors. That language has to be there. Consequential damages, incidental damages, the best way to think of these, believe it or not, you take a whole course in law school on this. Believe it or not, it's called judicial remedies. It's usually the course you take it in your last year when you're bored to death and just want to graduate, and they throw you with this course that teaches about all the different kinds of damages. Consequential damages are ripple effect damages. You know the butterfly effect, where a butterfly flaps its wings in the Congo and we get Hurricane Katrina? Because that is an example of what consequential damages are. Things have ripple effects. If you get drunk and you drive your car into a telephone pole, and that telephone pole causes a chain reaction that knocks down 10 other telephone poles, and that 10th telephone pole drops into a puddle of water and electrocutes somebody, you should not be liable for the electrocution. Okay? And by the way, that is an actual case from the 1920s. It's a famous case. Benjamin Cardozo, one of the great justices of American jurisprudence, was the guy who decided this case. It was called the Paulsgraf case from the 1920s, but that was the exact fact pattern. Somebody hit a telephone pole, it knocked down a series of poles, and the last one electrocuted poor Mrs. Paulsgraf. You don't want to be liable for things that are true, that are not reasonably foreseeable, and that's what that language gets you. The second type of limitation of liability, even if you are liable, your liability is limited to the total fees paid for my services. Even if I totally screw up, I bite the pooch, it's my fault, I did it bad, my bad, as they say on South Park. All I have to do is give you your money back, and that's it. You can't sue me, you can't go after my house, you can't do anything like that. All I got to do is give you your money back, and that's it. Those are your damages. It's a very good thing. Put them in your contract. Sometimes the courts will not enforce them, but it's much better to have them in there than not. Okay, strategy number 4, putting your assets in someone else's name. People talk about making themselves judgment-proof. You'll hear that expression. A homeless person living in the gutter is a judgment-proof person. He may do some bad stuff. A lot of homeless people do bad stuff sometimes. And you can sue his ass off if you want to. But guess what? The guy's got no money. He has no assets. He always got a bottle of Ripple, which he'll be happy to share with you, right? That's what being judgment-proof means. Being judgment-proof is you can sue me all you want, but I ain't got nothing to go after. You're impoverishing yourself. You are turning yourself into a pauper by doing this. I'm not saying you shouldn't do it, but you got to be very careful if you do. If you do this, first of all, the time to do it is at the very beginning of your business. When you start your business for the first time, that's when you do all this stuff. Do not wait until someone is threatening to sue you and then start putting assets in other people's name. That doesn't work. The court calls that a fraudulent conveyance, and they can actually set that aside. So don't do that. Do it now. If you're just starting out in business, now's the time to create these things. As long as you do it before somebody else has rights against you, the courts will enforce it. Make sure when you do this, you observe the legal formalities. So if you're transferring title to your house into your spouse's name, record a deed in the local land offices. It's called a quitclaim deed. That's the technical term for it, where you're basically saying that for love and affection and above, I'm transferring my half of the house into my spouse's name. Make sure you do that. If you're giving a ring to somebody or an item of personal property, there's a document called a bill of sale that you should do. follow the formalities. Make sure that you are making a legal transfer. And remember that when you're doing this, you are making a legal transfer. You no longer own this asset. If you and your spouse just get divorced at some point, you can't go back to her and say, hey, wait, I was just kidding about that. I really didn't want you to have all that stock. You give it back. You can't do it. You've done it. You've transferred the stock. That's her asset. And in a lot of jurisdictions, the divorce court will award it to her because you gave it to her of your own free will, or him, depending on who the spouse is. Civil unions also, by the way, same rules apply. No different. Okay. Make sure you don't. If you are at all insecure about your marriage, do not do this. Do not do this at all, okay? Last thing, and this is very important, if you are transferring an asset to someone other than a spouse, okay, mom, dad, sister, brother, make sure they change their will so that if they should die in an auto accident or something horrible, that you get the asset back. I had a client, one of my very first clients. This is a guy, he was a single gentleman. He never married. He had this beautiful house in Westport, Connecticut, which is a very upscale suburb of New York City. $3 million house, gorgeous place on the water. He owned it outright. He had paid off his mortgage. He'd gotten lucky in business, and he paid off his mortgage. And he was thinking about buying a business, and he was just concerned. He didn't want to lose that house at all. So what he did, I was not working with him at the time. I did not advise him to do this. He was unmarried. He didn't have a spouse, but his mom adored him, his 88-year-old mom. Okay, so mom was sharp. She knew what she was doing. He did the house in her name. He did a formal deed for, actually a little bit of money, too, which made it even more enforceable. He did all the legal stuff right, except he forgot to change mom's will. So when mom, 88-year-old mom, died a couple of years later, the house went into her general estate, meaning that he, the son, and his 5 siblings each owned a piece of this $3 million house. And guess what? They didn't get along very well. That's when he called me. That's when he called me and asked if I would be his lawyer. It took us 5 years and over $1 million to buy back the title to the house that he had initially when he deeded it to his 80-year-old mom. So just be very careful when you give assets to people that are not a spouse or a civil union partner. Make sure that they change the will so you get it back. Okay, so now what is this 5th strategy? What is this most effective strategy in the world for preventing lawsuits? Well, I need a fanfare for this. I wish we had sound effects on this thing. The key to avoiding lawsuits: don't do business with crazy people, even if they have lots of money. I think Bud would agree with me on that. Okay? Seriously, you do not have to take on every person who comes in the door. And let me tell you something. Whenever a client of mine gets sued or has a bad experience with someone, the very first words they utter, almost the very first words they utter that come out of their mouth is, Cliff, I knew it. I knew it. I knew this person was going to be in trouble. They acted weird from day one. Your gut is very, very well tuned, much better tuned. It's a lot smarter than you are sometimes. Listen to it. If somebody comes on weird, if somebody does something strange in their initial meeting with you, listen to this. Do some research on people. Find out if they bring lawsuits against people. Believe it or not, there's ways you can search for that online. Take the time to do some diligence. I mean, I have clients who have private investigators, believe it or not, that will do like background checks on new clients, especially if a significant amount of money is involved. Yes, that costs money, but do it. Find out that, because the minute you let one crazy person into the mix, you are opening yourself up to a world of hurt. Now, of course, I'm being a little facetious here. None of us does this perfectly. Even I occasionally let a wackadoodle into the fold sometimes. Because although if they get past me, they're pretty damn good, I will say that. But every once in a while, you might get one, but keep them to an absolute minimum. 99% of your sleepless nights comes from 1% of your clientele. Keep that 1% out of your pocket here. Okay, let's move on a little bit. Now, those are the strategies for avoiding lawsuits. If you are threatened with a lawsuit, first of all, it's very rare that people will go to court and file papers immediately when they sue you. Very often, what most people will do if they have a beef with you, they will send you a threatening letter of some kind saying, look, you ticked off my client here, you owe them this much money, whatever, please call me to discuss the situation, otherwise we will have no choice but to sue you. You get a warning here. Take it seriously. First thing you should do, read the letter carefully. Who is it from? If it's from the person themselves, chances are they're not likely to sue you. They just want to get your attention and talk through the problem and see if they can work out a settlement. And maybe you want to do that, maybe you don't. That's entirely up to you. But it's not, on a scale of 1 to 10 of being a serious threat, I would take it as maybe a 3. If it's from an attorney on a letterhead, the risk here now has gone up to about a 6 or a 7. This person actually spent an hour of an attorney's time to write this letter. They spent money. That means they're serious. They're willing to throw some money at this to get it resolved, and that makes the threat a little bit more serious. And it's from a local attorney. Somebody in California thinks that you owe them money, and they hired a Connecticut attorney in your backyard to write this letter. I would take that as a threat of 9. That's a DEFCON 3 situation. At that point, I would go to an attorney. These people have taken the time to find and hire a local attorney because they know that's where your assets are, and they can put liens on them and stuff. That's a serious threat. Also, look at the language in the letter. Does the letter say that they will sue you if you don't respond, or only they will have no choice but to sue you, or they will pursue all available legal options against you? Believe it or not, this language is significant. If I threaten somebody in a letter that I will sue them, if I do not hear from you by midnight on such and such a date, I will sue you, the law requires that I follow up on that. I cannot back off on that. I must do it. That's why if you look at the letter very closely, an attorney will mostly waffle on this. They'll say, if I don't hear from you by thus and such a date, we will have no choice but to pursue all legal. That's how we get around that. We're not saying we will, we're just saying you leave us no choice, which is accurate enough as far as it goes. Watch that language very carefully. That will give you a clue as to how serious it is. Okay? Obviously, you have a choice. First of all, if you ever get a letter like this, talk to a litigating attorney. Do not take it lightly. You know, after a while, you'll learn that some of these things you can blow off and some of them you can't. But in the beginning, don't. Get an attorney, spend a half an hour with them, get them to assess the likelihood of the threat, and especially, should you make a settlement offer? Should you try to make this person happy, make them go away? That's entirely up to you if you do or don't. But if you do respond with a settlement offer, be sure to state clearly that you're doing so is not an admission of liability. There's very standard language for this. I am making this offer of settlement only. I am not admitting any liability, because otherwise, if you do, it could be seen as an admission that you did screw up. And that can have repercussions for you if it actually does end up in court. Okay, so that's now the threat of a lawsuit. Now, if you're going on with court papers here, don't call me, okay? I know you got my contact information because of this program, but seriously, do not call me. I don't litigate. I am not a gladiator. Those of you who have met me know I do not look like one. I'm never going to fool anybody in that regard. I am a facilitator. I am not a gladiator. I am not a pit bull. I am a Pomeranian, okay? I settle disputes. I try to make them go away. I don't fight battles. What you need now is someone with a suit of armor and a sword. If you are being sued in an out-of-state court, you might get an attorney's advice here. You might be able to blow it off and avoid appearing. So let's say someone in California sues you, and they bring the action in a California court. Okay, you may decide that it's best not to go out to California and defend. Don't show up. That way they get what's called a default judgment. And then what they will do is they will try to enforce the default judgment in Connecticut, which is very difficult to do. A Connecticut judge is not likely to allow a default judgment in another state, especially a state like California, which is a million miles away. What the judge here is likely to say is, you know what? A citizen of the state of Connecticut was denied their day in court. We're not going to enforce this default judgment here. The California guy has to come here and litigate here in Connecticut. Now, if the California guy does that the judge has to listen to. If the California guy sues in Connecticut court, then you must show up. If you don't, that's a default judgment that could come back and haunt you. But if they want to drag your butt to Hawaii or someplace like that, you do not have to do that. You can take the default judgment, and in most cases, nothing bad will happen there. But make sure you get an attorney's advice before you do that. Here's one of my pet peeves. If you have a business, a corporation or LLC, when you first formed the corporation or LLC, you had to designate somebody called a registered agent. You probably remembered this. Well, that person's full title is registered agent for service of process. And that person, basically, this is the person where if the Secretary of State ever gets litigation papers from someone who's trying to sue you, that is the person that they send it to. And if that person no longer exists or has changed addresses or has retired from the profession of law, if they're a lawyer, guess what? That paperwork is going to sit and sit and sit. And if you do not respond to it, in some cases you have to respond within 10 days, you may lose your right to defend the lawsuit. That will be considered an admission of guilt. So if you have a corporation or LLC, always make sure that your registered agent information is accurate and up to date. Now, some of you are saying, well, yeah, why should I make it easy for people to find me? Well, if you don't, and someone tries to sue you, and all the Secretary of State has to do is send it to the registered agent. There's no guarantee they're going to get it. If the registered agent is no longer there, you may end up defaulting in the lawsuit without even having a chance to respond, even though you may be in the right. Always keep that information up to date. Let's talk just for a minute about small claims court. For those of you who are interested, I do have a whole program on YouTube, which is also one of my SCORE programs. It's called Dealing with Deadbeats. For those of you who people owe you money and you want to sue their tails off, that's the program you want to watch. I have a whole set of slides on small claims court and what you have to do. At this point, I'm only talking about defending a small claims action. First of all, in Connecticut, you can only be sued for up to $5,000. In other states, New York, for example, it's $7,500. Every state has a threshold. You want to know what the threshold is. If someone ever brings a small claims court action against you, watch lots of television. Programs like Judge Judy, these judge programs, a lot of these you should be aware. These are actual small claims court cases that are being brought in cases around the country. Oh, they're probably actors, acting out the parts, but these are actual small business cases. Watch lots of them. Watch what the judge does, okay? Listen, because that's going to be your experience. These shows are actually good for showing you what life in a small claims court is all about. Prepare, prepare, prepare. The better prepared client almost always wins in small claims court, almost always. Surviving your day on court. Be in time. Show respect for the court, but don't use legal language. Courts hate it. Small claims courts are meant for informal resolution. If you get up there and you say, may it please the court, they're going to know that you've been talking to a lawyer, and that's going to make the other side look a lot better. The judge's sympathies are automatically going to go to the person who hasn't been talking to a lawyer, so don't do it. Just state your case, just the facts, have your paperwork there. You've seen Judge Judy. When Judge Judy asks for a document and the person doesn't give it to them, that person loses, okay? Stay in small claims court, okay? Stay away from lawyers. If it doesn't go well, okay, if you sense that the judge is really hostile, what I would suggest you do is offer an on-the-spot settlement. Say, you know what, Your Honor, you're right. It sounds to me like I really don't have a strong case here. Look, I'm willing to settle this for 50 cents on the dollar. Can you see fit to do that? I just don't have the money to pay all of this. Can we settle this? Again, one of a judge's goals is to make their life as easy as possible. What are you doing here? You're making the judge's life easy. You're making it easy for him or her to make a decision that will make the other side somewhat happy and whatnot. So you've just saved yourself 50 cents on the dollar by doing this. Don't be afraid to do it. Because if you do get a judgment against you, in most jurisdictions, the person can do all the horrible things that they can do in a real lawsuit. They can garnish your wages. They can freeze your assets. They can seize your assets. You don't want to go there. If you sense that you're really losing the case, offer a settlement. 9 times out of 10, the judge will work with you, and you'll get it. So here, I see we're almost at 45 minutes here. Here are my key takeaway points. There is no effective strategy for preventing lawsuits, but by running your business properly and adopting the 5 defensive strategies that we talked about, you will probably reduce the odds of a lawsuit by 99% or more. Don't transfer assets into your spouse's name if you are at all insecure about your marriage. Make sure your business address and registered agent information listed with your Secretary of State's office is accurate and up to date. If you are being served with papers, those papers must reach you quickly so that you can respond. And then last but not least, don't do business with crazy people. If a prospective customer or client has lawsuits stamped on their forehead, send them to your competition. It's okay. They may even send you a gift basket come holiday time. That is all I have to say. These are 2 of my best-selling books. The Small Business Survival Guide has whole chapters going into some of the stuff we've discussed. And for those of you who sell on eBay, this is my best-selling book for eBay sellers on the legal and tax issues. I also got a bunch of books on other topics, but these are the 2 that I thought were most relevant. And this is what I look like. This is my contact information. But remember, I don't litigate. Don't sue. If you're being sued, don't call me. Get a real lawyer who fights battles and looks like a gladiator. So with that, I'm going to turn the program back to the SCORE people here. I know you got questions, and I'll try to answer as many of them as I can.
Thank you very much, Cliff. I think you look like a gladiator in that picture. Yeah, it's quite gladiator-ish. And we have lots of questions. Let me start at a couple people asked if the slides are available for, yes, they are. They'll be at scorefairfieldcounty.org. You can see that website right at the bottom of Cliff's slides, by the way. And in about 4 or 5 days, they'll be there for your review. Going back to do these in chronological order, I think we can do that pretty easily. The question from Michael Hicks, way back on an early slide. Does the $10,000 to $20,000 barrier apply to patent trolls too? I don't even know what a patent troll is, but I assume you do.
No, I do. A patent troll is somebody who, basically applies for a patent, and they let the process, go on and on and on. They never really get a resolution, but then when you file your patent, they come out of the woods. We used to call this a submarine patent for that reason. The answer is, you're talking here about, I guess, you're on the plaintiff side here. You're talking about suing a patent troll. The answer is yes. Because it's patent case, you're going to be in federal court. So you are definitely going to spend at least $10,000, $20,000 on that. That's a federal cause of action. You can't bring those in state court of any kind. So the answer is yes. If you're going to sue somebody else, you got to really make it hurt. Check out my Dealing with Deadbeats program. I actually give you some very good information about what to do in a situation like that when you have to sue somebody but you don't have a ton of money to do it. This program is more on the defensive side. Mr. Rosenberg's question in looking at errors and omissions coverage, it seems to be geared with large corporations with many procedures, and any suggestions for getting this? The answer is you can get errors and omissions coverage as a consultant. In fact, depending on the consulting work you're doing, if you're consulting in an area where people could be injured if you give bad advice, that is something where I would definitely look into it. And you can definitely get, it's not just limited to big corporations at all, although it might be pricey depending on the type of service you're doing. Get yourself a good insurance agent, somebody that does liability coverage. The person who handles your life, your disability, is probably not the best person to handle liability. The insurance people who do liability coverage generally are specialists. They don't do anything else. Get yourself somebody who knows what they're talking about and get as much as you can afford. Okay.
Susan's question, I kind of answered already.
Yes, so some of the questions about the slides, they will make them available.
So go to Leonard's first question.
Leonard, I would like to know the information. I do have an LLC. I would like to know your contacts. Okay, that's great. By the way, SCORE is a wonderful resource. I've been doing these programs for 36 years, and obviously I'm a big fan of SCORE, but I have to tell you, this is the most amazing thing that the government does for you, and it's absolutely free. When you are starting out in the business, you have a million questions. These guys help you find the answers, and they don't charge you. It's an amazing resource. I have never in 36 years sent a client to SCORE who has come back and said, you know what, this is a waste of my time. Why did you do this to me? You know, this guy didn't know what he was talking about. That never happens with SCORE. You know, 9 times, I mean, obviously, a lot of them don't call me back, obviously, but the ones that do almost always say, this was worth the time and effort. I think I got my head screwed on straight now because of my counselor and what he's done for me. Take advantage of this, okay? And I would say that even if this wasn't a SCORE program. Ms. Adams, I have a friend who suggested starting another business, a mother business, and putting all their assets into the mother business so it would be more difficult to find the assets. Okay, generally speaking, don't play shell games with this. There is something you can do called an asset protection trust, where you put all your assets into a trust, and that is, it's like the blind trust that the politicians do when they take office. It's the same basic concept. The problem with an asset protection trust is that the trustee has to be completely independent. You cannot create an asset protection trust and make yourself the trustee and the beneficiary. That will not fly. You have to get somebody who's truly independent, and they own your asset. So if you're putting the house into the asset protection trust, that house now belongs to the trustee. You are merely a renter in that house, and you have to be prepared for that. If something happens to you, the house doesn't come back. The house goes to the other beneficiaries of the trust. So be very careful here. Do not play shell games with assets, with corporations. The judges really hate that when they see you doing that. It shows them that you have something to hide. Seriously, don't do that. Okay? Where to look to see if a client has a habit of litigation? Well, this is what social media is all about, people. This is how you network. You know, find out if someone has brought lawsuits against people. They will give you little clues. Here's one of mine in my world. This may not apply to you. Cliff, you know, you're the 4th attorney that I've called now in the last year. These other 3 guys that I talked to were idiots. They didn't know what they were talking about, but I kind of like your web profile, and I think you've got a brain that these guys don't have. The minute I hear that, I mean, red flags start flying all over the place. Okay, not every lawyer out there is Cliff Ennico. I totally get that. Some people may have had a bad experience with an attorney at some point. I'm not saying it doesn't happen. It absolutely does. But to have 3 bad experiences in a year, forgive me, dude, that sounds like it's more you than them, okay? And that's what I'm going to start doing some asking around. Believe it or not, people do have reputations, and it sometimes helps to talk to an attorney in town. You know, someone you don't plan to hire, but just say, look, I'm thinking about being approached. What's this guy's reputation? Is this the local developer who sues all his subcontractors and stuff when things go wrong? You know, people do get reputations, and if you catch the right attorney, they'll share information with you about this, unless, of course, they represent that person, in which case, of course, that's not going to happen.
Cliff, there are a couple in here that are kind of related to that same subject, like the next one from Venkat is, can you ask your potential clients if they've sued anyone in the past? And then down, Barbara Cleveland has asked the same question about where you go on the web. So maybe you go back to Venkat's question. How do you feel about asking somebody?
Yeah, well, I'll be honest with you. First of all, you know, you can always ask, you know, if they've ever sued somebody. But I hate to say it, from a marketing point of view, it's not a very good thing to do because you're sending a signal that you're a little bit of a wackadoodle yourself. You're a little bit paranoid about this, and it's not a good thing to do from a marketing perspective. I would say don't ask that question. If you can at all avoid to do so, do some research, find out. I mean, one thing that people don't do often enough, don't be afraid to ask clients for references. You know, people always ask professionals for references, but there's no law that says, especially if there's a large amount of money involved, don't be afraid to ask for financial references, things like that. Talk to somebody other than that person. Find out what organizations they belong to, and then call other people in the organization that you know. So if they say they belong to the Bridgeport Chamber of Commerce and you belong to that organization, call some other people in the chamber saying, I've just been contacted by Joe Blow. You know, what's his game? Is he somebody you would deal with? You know, don't be afraid to do stuff like that. That's how this information will surface. And then just trust, I mean, I can't say this strongly enough, trust your gut. 9 times out of 10, these people advertise that they're going to be a problem. I got a call 3 days ago from someone who had obviously a bad experience with a local contractor. And all this person did, she left me a 3-part voicemail where all she did was rag on this contractor and how bad he was and everything like that. I looked the contractor up online. He's Better Business Bureau, 5-star rating on Yelp.com. Nobody's ever said anything bad about this guy. This person has left a 3-part message, basically saying that he's the Antichrist. Who am I going to believe here? Right now, my gut is screaming, get rid of this person. Do not take this client on. Refer them to your worst enemy. Let them deal with this. And by the way, I never send those people to score. You should know this. I should say this in this room. I will never send you somebody that I think is a wackadoodle. So let me just say that right now. Lucy Langley, can you talk briefly about D&O insurance? The answer is yes, very expensive. But if you have a corporation or LLC and you're thinking of hiring outside directors who are not going to be part of the management team, it's something you're almost going to have to do. I will not serve on a board of directors of any organization, even a nonprofit, without knowing that there's insurance. And I hate to say it that way. It's one of the reasons I don't sit on as many nonprofit boards as I should. But I don't want to get sued because the organization does something stupid. And that is a risk that people have. If someone is suing someone for false information, can the other person sue them back? Absolutely. It's called defamation of character, libel, or slander. You can definitely sue them back, but that's not what people do today. People don't sue on stuff like this. What they do is they go on Yelp.com, or there's one called Avo.com for attorneys, and they give you a bad review, a 1-star review. That's what they do. And it's very hard to respond to those without sounding like a wackadoodle yourself. I have to be very careful. For example, if someone posts a bad review for me on social media, I have to be very careful because if I respond in too great detail, I'm disclosing the confidential information of my client, and that can get me, I can lose my license for that. So my advice to attorneys, I actually do a program for attorneys and how you deal with negative reviews and stuff. When in doubt, just don't respond. Most of the time when people post these things online, they go into such emotional detail that anyone who looks at it will see that they're the wackadoodle and not you. And by responding to it, you're actually in a way justifying it, in a way. Stay out of the fight, or the best possible response when somebody posts a negative review is to go online and say, you've obviously had a bad experience, with us. I really apologize for that. Please call me. We'll do everything we possibly can to make the situation right. That's it. 9 times out of 10, the person will not respond to that, but you sent the signal that you're the good guy here. You're the sane person, not the wackadoo. It's just a good way to respond to these things.
I think we've answered Barbara's questions. I hope we have, Barbara. We've got about 5 or 6 more to go here, so let's go to
I can go a few minutes over if
if
the software will let me. Who should ensure my liability covers as a subcontractor? My direct client or the end client that I can't really tell. This sounds like a general contractor. First of all, when you're a general contractor, there are things called mechanics lien waivers that you need to know about. That's one way of making sure that a subcontractor doesn't sue you or doesn't sue the homeowner, which is even worse. The general contractor's nightmare is the plumber doesn't do good work, the plumber doesn't get paid, there's a dispute, and the plumber puts a lien on the homeowner's property, which is under construction, so now they can't get the certificate of occupancy, and now the homeowner wants to sue the general contractor for screwing up with the plumber. That is we call that the rondelay. Everybody's threatening everybody else and going and suing a third party. Lien waivers are the way to get around a lot of this sort of stuff. I don't do a lot of work with contractors, really, but I know that the lien waiver system is something you need to know. Is there a time limit to suing someone? The answer is yes. There's a statute, it's called a statute of limitations, but there's a lot of ways that people can get around that. What I tell clients to do, if they have a claim against somebody that's more than a couple of years old, send them a letter, certified mail, reminding them of the situation and asking them to address it. They probably won't respond to that letter, but by doing that, you've just refreshed the statute of limitations. The statute of limitations stops ticking at that point, or it starts over again, from day one. And in a situation like medical malpractice, for example, which has a very short statute of limitations in Connecticut, you want to make sure that you don't blow that statute of limitations. Once that statute of limitations passed, if you haven't done anything to revive it, it's gone forever. You can never bring that action against people.
So the next two are compliments, so we'll just skip right over those.
Yeah, I know. You guys never let me read the compliments out loud.
Forget that. Go on.
It's all the bad stuff here. Cliff, I dealt with you 3 years ago. Okay.
Adrian's got another question.
Adrian, okay, special considerations for asset protection in a real estate investment business. Yeah, you guys are the trust people. You guys use all kinds of fancy stuff, trusts and special purpose limited liability companies. I'm not a real estate development attorney per se, but you need to get an attorney who works with real estate development people, because they have all kinds of special tricks that they do with multiple layers of trust. But of course, you're a real estate developer. You're Donald Trump. You can afford this, okay? You don't need little Cliff Ennico here. You can afford a real lawyer, so go get one. I'm sorry. Kyle. Hey, Kyle. Given my situation, it might be necessary for me to sue someone, but it wouldn't make sense for me to go broke in the process. So is it possible to find a litigator who would work on contingency? Some litigators will work on contingency. Generally speaking, though, in business cases, they tend not to. Working on contingency, when a lawyer takes a case on contingency, meaning he will not charge you only if he's successful. He'll take a third of the winning judgment, and only if he wins. Most attorneys who take that kind of thing on only take those cases on if there's a high probability of victory or settlement. So, for example, personal injury cases. Hardly any personal injury cases go to court anymore. They all get settled by the insurance companies out of court. So if that's the kind of case you're talking about, you can certainly find an attorney who will take a case on contingency. But, for example, if you have a dispute with a partner and you want me to get involved, I can't do that on contingency, because I have no clue whether or how it's going to go. I mean, one thing, the dumbest mistake that I can make as a lawyer is to get involved in a case where I'm spending 30, 40 hours a week on this case and I can't get paid because of the promise that I made to the client. And every attorney is sensitive to that whole issue. So I don't really think you'll be able to get a lawyer to work on contingency unless it's such an open and shut case that, that it's, you have an agreement, it's the agreement is 100% in your favor. This case is almost a waste of time. In a situation like that, an attorney might be willing to take it on contingency, where all he has to do is get into court and get it dismissed in 30 days. He might be willing to do that on contingency. But of course, in that case, there's no recovery. So you got to be careful there.
So go to Anna's follow-up question there in the next one.
Can a limitation of liability disclaimer, the answer for a laundromat business? Well, the answer is yes, but in that kind of a business, you generally don't have a contract with your customer. The person just comes in and does their laundry. So if you fry their underwear, there really isn't. All you can do at that point is to post on your front door, terms and conditions for use of the laundromat, and hope that that will work. There are a lot of contract people. That's why I said when I talked about contracts before, you notice I included invoices and purchase order forms. You can do a purchase order or an invoice with a whole bunch of terms and conditions on the back of it. You can certainly do that, and that's where your disclaimer language would be. People ignore it. They never even look at these stupid things. It's like those web contracts where you say, I agree. You haven't looked at it. Nobody looks at those things, right? But that's where your disclaimer language needs to be in those documents. That can be a contract if you do, and if they don't counter with their own terms and conditions, then maybe your terms and conditions will prevail in a court of law. It doesn't hurt to try. Or you have the rules for the laundromat, which appear in the front. No flirting, no nothing like, of course. By the way, if you are in a laundromat business, you are in the singles, you are in the romantic consulting business. You are aware of this, okay? People are looking to hook up in your laundromat. So be aware of this. This is a service that you are providing for which you are not getting paid, but maybe you should. No, seriously, you can do monster.com, but the local laundromat is. I mean, from what I remember, of course, I'm going back many years now since my single days. But I remember that the laundromats were kind of cool. You never kind of used the same one twice because you were looking for the network, shall we say, with a different.
We're getting a little bit off the subject.
We always do in these.
So this is the last question. Leonard's got it. He's won a prize if we awarded them for such thing as having posted 3 questions. And we'll stop it with this one, but give
let me do this one. I am planning on doing YouTube video, giving people advice on how and what I did to create income. Is that okay for me? The answer is absolutely yes. I have a YouTube channel with 38 videos, and most of them don't have to do with legal stuff. I have a video right now with 175,000 views on how to sell anything to anybody, believe it or not. A lawyer teaching you how to sell. Believe it or not. And I got 175,000 views. Seriously, go to youtube.com and search either for Cliff Ennico or How to Sell, and I guarantee you will see this video. I am wearing the ugliest purple sweater that you could imagine. It looks like a piece of carpet that I ripped off the floor and threw it over my head. But seriously, YouTube is a great way to do things. Just be careful when you do a YouTube video. Always ask the question, can I be sued for anything I say? So, for example, if I do a YouTube video where I talk about one of my clients, okay, I can't really do that. Because even if the client has given consent, believe it or not, because I'm disclosing confidential information and by doing that in a YouTube video, I've totally blown the attorney-client privilege. If this guy gets sued in court, that information will be attainable by the other side. So, watch your legal liability, but yeah, otherwise do, and then send me a link, and I'll be happy to look at it.
All right, so I'm gonna relent here on what I previously said. Yes, that was Cliff. He had a bout of pneumonia over Christmas. He's done an unbelievable yeoman's job. Can you take a swing?
I was holding that back for like 45 minutes, man. It was unbelievable.
Well, we'll let you. Great. We'll just end it right now. And thanks for that. It was great. It was really excellent. And for those out there, thank you very much for attending. A reminder, we have another webinar in 2 weeks, January 24th, Budley Freund on Basic Tech Trends 2. An update from the one he did about 3 or 4 months ago, so please join us for that. And again, Cliff, thank you very much, and thanks to you out there that have joined us today, and we'll look forward to seeing you or listening to you or answering your questions at the next webinar. Thank you very much, and have a good day.